So, Madam President, Your Honours, before the break, we were discussing Command Circular number 16 of 2016 and the issuance of PNP Investigative Directive number 12 of 2016, which set out additional policies and guidelines in the conduct of double barrel. This directive instructed investigative units on how to perform their responsibilities in the case of armed confrontation during the implementation of Operation Double Barrel. The document also included an exhortation to monitor human rights violations perpetrated by PNP operating units. The term neutralization itself is, of course, not defined anywhere in any of these documents as meaning to kill, a point the prosecution itself conceded at that moment in time when it was seeking the opening of an investigation. And I refer, Your Honours, to ICC 01 on 21, document number 7. So, the prosecution, throughout its pre-confirmation brief, invites this chamber to find, by inference, that neutralization means murder, and even carves it in stone as its formal statement of the common plan. But we, the defence, can show that the term neutralization can only mean the use of self-defence where officers' lives are endangered. For this, the text of the circular must be read in the context of the governing framework and other PNP directives. It is our submission that across the political, legislative, judicial, and law enforcement contexts, the consistent articulation has always been that neutralization denotes lawful restraint. At the executive and operational level, the Chief of the Philippine National Police, Ronald de la Rosa, Bato, publicly clarified in 2017 that neutralization means arrest. Furthermore, in an official transcript dated 28 October 2024, the former Chief of Police, De La Rosa, testifying before the Committee on Accountability of Public Offices and Investigations, testified that the term neutralization was anchored in the PNP Operational Procedures Manual, where it is specifically and strictly defined. Let us just have a look at what he said. And for your ease of reference, we will also display the said passage in the PNP Operational Procedural Manual to which De La Rosa referred, which incidentally was published in 2021. Neutralization, and I quote, "A police intervention in strict accord with the use of force continuum and/or principle of proportionality on the use of force purposely to contain or stop the unlawful aggression of the offender. This may include an arrest, capture, surrender, or other acts to subdue the suspect." It strikes us as rather mind-boggling that the prosecution should have failed to appreciate the significance of this. It was aware of De La Rosa's speech because they disclosed it to us. But the prosecution's investigators clearly never bothered to read the procedural manual to which De La Rosa was referring. In fact, we know that they didn't, because it's not on their list of evidence. Within the judicial sphere, when the terminology was examined before the Supreme Court of the Philippines, in petitions challenging aspects of the anti-drug campaign, the government defended the circulars on the basis that they did not confer a license to kill. The Supreme Court of the Philippines, however, to date, has declined to issue any ruling declaring the campaign unconstitutional, has declined to invalidate circulars, and has declined to rule to date that neutralize or neutralization means to kill. The Supreme Court's treatment of the issue is particularly instructive. The Court observed that the wording was neither novel nor introduced during the Duterte administration. It had already appeared, for example, in the 2014 revised PNP Manual on Anti-Illegal Drugs Operations and Investigation. In other words, the term formed part of the existing police vocabulary. The Court further clarified that the mere inclusion of the term in a circular does not render that instrument unconstitutional, especially where the circular expressly mandates compliance with internationally accepted legal principles, public policy, and the full observance of human rights, as we showed you earlier. No circular has been invalidated on this basis, nor has it ever been established at the highest level of domestic judiciary that to neutralize means to kill. The judicial record does not sustain such an equation. In each institutional setting, therefore, the term has been situated within ordinary policing powers and constrained by the lawful use of force framework. The testimonies of those operating within that framework, the prosecution's witnesses no less, are aligned with this documentary record. For example, witnesses P1158 and P1170 explained that neutralize means to arrest or to incarcerate through legal means. It did not mean to kill. Witnesses P1050 and P1174 confirmed that lethal force arose only where a suspect's resistance placed an officer's life at risk, reflecting the ordinary doctrine of self-defense and consistent with Mr. Duterte's repeated public declarations that force was justified only in such circumstances. P1214 further indicates that operational decisions were made by officers on the ground within established protocols. So,
I'm sorry to interrupt, counsel, but once again, you need to be specific and provide the document reference number. You must specify the document number, the reference number for us.
if I may, Madam President,
Merci beaucoup,
of course,
Thank you very much.
an understanding with the Learned Chamber's legal officers that we would be able to provide references after the hearing. But of course, the document that I was referring to is PHL OTP 00090518-R01. So, Madam President, Your Honours, taken together, the manual, the public clarifications by police leadership, the state's position before the highest court in the Philippines, and even the prosecution's own corroborative witness testimony, all of this material demonstrates a coherent and consistent understanding that neutralization was articulated as lawful incapacitation through arrest and related measures, not as a policy of killing. And if the prosecution's case for the common plan in counts 2 and 3 is based on Command Circular number 16 of 2016, we might as well pack up and go home because Mr. Duterte is simply not guilty. However, for the sake of completeness, I continue. The fifth indicator of a common criminal plan, as alleged by the prosecution in paragraph 28 of the pre-confirmation brief, appears to be the concerted broadcasting of inflammatory speech. Here the prosecution once again selectively cites excerpts from 2016 media interviews with Ronald De La Rosa, Bato, and Vitaliano Aguirre, which suit its purpose and case theory, while totally ignoring the more unequivocal comments in those interviews which destroy its case. Regarding the interview with De La Rosa, mentioned in paragraph 28, after supposedly inciting a crowd of drug addicts to cause criminal damage to the properties of their narcotics suppliers, the newly elected chief of police states, "It's either you will die from police gunfire," and he adds, "if you resist." That's PHL OTP 00000849, page 2. Likewise, with the comments in an Al Jazeera interview, PHL OTP 00090340, comments attributed to Aguirre, from which the prosecution imputes criminality to Rodrigo Duterte by citing Aguirre's comment that the administration's policy was to stop crime and kill drug lords. Such throwaway comments reflect on Aguirre alone. And God forbid we're not alleging that Aguirre did anything wrong. Especially when, in the very same Al Jazeera interview, Aguirre states, not once, but twice, that the policy of Duterte himself was for the police to use lethal force only in self-defense. We can display that on the screen, and the part that I want to read is highlighted. And President Duterte was very clear on this matter, he said, Aguirre, that there will be no killing of unarmed offenders, meaning to say that you use force only when your life is in danger. Later on, in the very same interview, Aguirre would repeat the same theme which exculpates Mr. Duterte, PHL OTP 00090340 at page 4. And I read out the relevant passage which is highlighted once again. They are supposed to arrest them, but when they fight back, then the president has instructed them that they must first protect themselves. So much for Mr. Jeremy's elastic mouth theory. Even he thought that Duterte's speech was bifurcated, and even if he did think so, his so-called perpetrators did not. So why does the prosecution cite the excerpts which support its case so selectively? Well, I'm not going to impute any malfeasance, but I can hazard a wild guess. I would suggest that the people reviewing the prosecution's massive databases for suitable evidence are performing keyword searches. Most likely, some of the most utilized operands were the words kill and perhaps sometimes neutralization or neutralize. Once the member of the prosecutor's staff has his hit, he excises the excerpt, rejoices that he can slot it into the predetermined case theory, and does not bother to read the rest of the item of the evidence, where the exonerating evidence is unequivocal. Turning to the sixth indicator of the supposed criminal plan, as set out in paragraph 29 of the pre-confirmation brief. None of the speeches imputed to the former president, nor the use of what the prosecution calls dehumanizing language, dehumanizing language by the alleged co-perpetrators suggests criminality. I would suggest that it is within the bounds of acceptable, albeit extreme political discourse, to refer to drug users in such a way as beasts, animals, or to the barangays as being plagued by the drug menace. Well, the last one is true. You can hardly expect populist politicians and law enforcement officers to refer to drug pushers and criminals as upstanding pillars of the local community. I really do feel that the prosecution is at a loss if this is its circumstantial evidence for proving the existence of a common criminal plan. The same goes for the seventh supposed indicator of criminality, which is based on the names created for the two police operations, Double Barrel and Tokhang, along with their supposed evocation of firearms metaphors. While the source for this particular gem, witness P1207, a self-confessed murderous villain, might have guns perpetually on his mind and insert their imagery into his daily speech, it does not mean that those who formulated the anti-drugs policy were acting under a similar caprice when they devised the nomenclature for these two particular police operations. And of course, there were other police operations with completely different imagery, such as the one-time, big-time operation referred to by a few prosecution witnesses, and the riding in tandem operation. The mind can only boggle as to what type of nefarious imagery the prosecution believes that last title evokes. None of the indicators I have mentioned up until now have shown in any way a mutual meeting of minds between alleged co-perpetrators, evincing a communality of purpose or an agreement to act in an illegal fashion. Of course, the prosecution has shown us pictures of the alleged co-perpetrators uttering comments similar to those issuing from Rodrigo Duterte. But this does not indicate a meeting of minds, as I will elaborate shortly. The eighth factor, purportedly evincing a plan of agreed criminality, is set out required for a common criminal plan, or a common plan. Concerning and coming to the ninth category of circumstantial proof for a common criminal plan, the prosecution relies on what it believes to be the Duterte's administration's unabashed publication of statistics recording the number of deaths occasioned in the context of the so-called war on drugs. But let us just look at how and where the statistics relied upon were being published. In two government reports, the first of which being the Duterte administration's year-end report for 2017, totaling 63 pages, covering every sector of government and the economy, and of which just 2 pages are devoted to policing activities. We can give you the document ID number shortly. It's on the screen. While the deaths of 3,967 drug personalities mentioned are indeed recorded, as Ms. Robin Croft so helpfully pointed out in her presentation, and are not insubstantial, these deaths comprise a fraction of the 118,287 total arrests for drug-related activities, especially when the government is conducting special operations in a concerted drive to curb the narcotics problem. Such statistics are certainly not indicative of a wholesale policy of murder designed to supplant the process of law. If they were, then certain Latin American state parties would have regularly equaled or exceeded the Philippines in the number of law enforcement killings per capita of the population. What is quite egregious, however, regarding the prosecution's reliance on the 2017 Key Achievement Report is the way in which it glosses over, or rather ignores, those pages which do not suit its case theory. Take, for example, pages 28 of the document, which highlights the fact that 1,900 drug-related investigations had been carried out against law enforcement officers in the preceding year, with 375 police officers being dismissed, including the 2 policemen involved in the murder of Carl Arnaiz, who were later convicted and sentenced to life imprisonment. These policemen were affiliated with the Caloocan City Police Station, and where, so the report mentions, 1,000 personnel belonging to that station were sent for retraining. To conclude, this document, far from being evidence of a conspiracy hatched between co-perpetrators, is in fact a testament to the Duterte administration's respect for the rule of law and written proof of its intolerance for rotten apple police officers. As for the second official publication, which is supposed to substantiate the criminal plan, we turn to the 2016 annual report issued by the Philippine National Police. The statistics are quoted, with all respect, in a misleading fashion. The tables used by De La Rosa, and particularly the pie chart, show a remarkably low incidence of deaths in comparison to arrests and voluntary surrenders. Obviously, the misleading aspect of that is the prosecution's representation of the statistics, not De La Rosa's. So, coming to the 10th and final source of circumstantial evidence, supposedly supporting the mutually agreed nature of the criminal plan. And this is the fact that the extrajudicial killings, to quote the prosecution's words, followed the same patterns and modus operandi, with the perpetrators covering their tracks. But here, let me ask a question which begs an answer. If the Duterte administration was so barefaced as to openly declare its intent to kill drug users and pushers and celebrate this, as the prosecution argues, in official governmental publications, why would it encourage the perpetrators to go to such lengths to disguise such an intent? I mean, of course, anything's possible. But I'm just pointing out the internal contradiction in the prosecution's case theory. In any event, as they say in English, there is more than one way to skin a cat. And the differing types of modus operandi that we have encountered in the prosecution's 49 incidents of murder involve all conceivable modes of butchery, ranging from strangulation, suffocation, to stabbing and shooting. Now, assuming that the prosecution can overcome the hurdle of proving the existence of a common criminal plan, how has it shown that the so-called co-perpetrators coordinated between themselves to reach a mutual agreement to execute it? Well, it hasn't. All it can do is show a selection of comments made by Mr. Duterte's closest colleagues in government, and all of which take their rhetorical cue from him. The prosecution then artificially defines the intended individuals, the identified individuals, as a collective of co-perpetrators. Now, common law jurisdictions, such as the one I come from, are familiar with these issues in the context of the law of conspiracy. The federal rules in the United States, for example, allow the statements of co-perpetrators to be used as circumstantial evidence, one against the other, to establish the existence of a conspiracy, but require that these statements be made during and in furtherance thereof. Narrative venting, which is what all these supposed co-perpetrators did, the ones identified by the prosecution, does not further the criminal objective. In furtherance thereof means that the statement relied on must advance the objectives of the conspiracy, such as through reassurances, updates, or actions taken to avoid detection. Now, I do realize, Your Honours, that there isn't too much jurisprudence on this matter, but let us look at it logically. Where can one really draw the line if it is sufficient to infer a mutual agreement to execute a criminal plan if we rely only on the statements of the people in the vicinity of a criminally verbose suspect because of the same quality of verbosity it alleges? This is what could be called bootstrapping logic, building on limited information with the very same information in an attempt to validate that information or to create a structure there without. Put simply, the prosecution has advanced its cart before its horse. It has merely selected a number of individuals working alongside the former president who made similarly offensive comments and has then called them co-perpetrators. Instead of seeking evidence which might shed light on the interactions of these individuals between one and another, and construing a criminal conspiracy therefrom, should the evidence even support such a hypothesis, the prosecution has taken its preconceived and predetermined premise of a criminal plan and forcibly superimposed it on these individuals. The artifice of the prosecution's working methodology in conjuring up this criminal collusion becomes even more apparent if we examine the evidence emanating from the crime-based perpetrators themselves on a granular level, especially from the prosecution's own star witnesses, three of whom supposedly formed the hardcore of a more limited organization referred to earlier in my submissions. I'm trying to comply with redactions. P1, for example, a self-confessed murderer whose recruitment by the prosecution will be examined elsewhere, was asked about the common criminal plan of his associates up to 2017. And this is what he had to say. Every time somebody was at fault against the government of Rodrigo Duterte, we didn't bother to send them to prison. We would just kill them. That's PHL OTP 0001 2584 at lines 248 to 250. Okay, and that was the audio which I just quoted, and here we have the transcript. PHL OTP 0001 2376 hyphen R02, lines 248 to 250. So, having given you that quote from P1, I would say that as far as this witness was concerned, the common plan was not a refined policy of cleaning up the streets, but rather a killing frenzy of the political opposition. Obviously, no such policy existed, and no such policy is alleged. P3, whose evidence relates to the presidential period, describes a similar orgy of killing without rhyme and without reason, but not drug addicts, nor alleged criminals, but rather was so petrified of not meeting this quota of slaughter that he was randomly grabbing and killing just so that there would be something to report on TV for the one-time, big-time operation. Now, I ask you, how can P3 have been operating under a clear criminal direction to target drug users for murder, criminals for murder, when he states that on occasion he would perform so-called clean arrests? It's the prosecution's witness, P3. He's not clear when he's actually following their supposed criminal theory or when he's is. What are clean arrests? These are arrests subsequent to which the apprehended criminal would be handed over for a judicial process. And so with that, I believe, I have exhausted the first limb of the objective requirement for indirect co-perpetration and have shown conclusively that there was no mutually agreed common criminal plan. Madam President, there are 10 minutes to go. I will start with the concept of essential contribution, which is indeed the second limb that I want to talk about with respect to this mode of liability, which requires the prosecution to show objectively that Mr. Duterte himself made an essential contribution to the furtherance of this scheme of criminality, and what is more, that subjectively he was aware that he was making such a contribution. This is what us Latin-speaking lawyers, would call the sine qua non test. Or to put it another way, did these 49 murders, which the prosecution has identified, occur specifically because of Rodrigo Duterte's involvement? Or, to make the logic a whole lot simpler, would Rodrigo Duterte's withdrawal from this criminal scheme to target suspected criminals, as alleged by the prosecution, have led to the avoidance of these 78 deaths? Let us see where this test is set out in the Ali Koshaib trial judgment. Paragraph 796. And I'm going to quote the essential part for the purpose of the essential contribution. The accused must make an essential contribution without which the commission of the offence would not be possible. To hold an accused liable as a co-perpetrator under Article 25(3)(a) of the statute, it has to be established inter alia that he or she had control over the crime by virtue of his or her essential contribution to it and the resulting power to frustrate its commission. Well, here, I would like to show you the statistics pertaining to the rate of killings since the former president has left power and the responsibility for law and order has passed into the hands of President Ferdinand Marcos Jr. I rely on a report published by academics at the Third World Study Center in the University of the Philippines in the context of what is called the Dahas Project. And trust me, the authors of this report, comprising weekly statistics on the first year of the Marcos administration from 2022 to 2023, are no great friends of the former president, Mr. Duterte. This report was even cited, I remember, in a Rappler article, but it's to be found on our list of evidence at PHL D36 0006 0001, pages 0006 to 0010. The report for the first year of the Marcos administration showed that out of 342 killings, 160 were at the hands of state agents. And the figures and the statistics just kept on rising, with the second year of the Marcos administration, 2023 to 2024, showing an increase in deaths at the hands of vigilantes, albeit a decrease in deaths at the hands of law enforcement officers, from 46.8% to 34%. Hardly a statistic to be proud of. So, with all the prosecutions, fancy bar charts, I'm pretty sure that if they were to recreate them for the period of 2 years after Duterte left power, they wouldn't have room left on their computer screen. The numbers would be so sky high. The conclusion is that there is no reason to believe that Duterte's disappearance from the political scene would have frustrated the ongoing incidents of murder at the hands of state agents or vigilantes. Clearly, I'm forced to ask myself whether anyone on the other side of this room has thought of investigating the Marcos regime and the related phenomenon and holding someone accountable. Why are my colleagues sitting to their right, the victims' representatives, not clamoring for accountability for those deaths? Or is it of no consequence now that Mr. Duterte is sitting in the ICC detention center? I've reached a natural break, Madam President, in my submission. With your permission, I would like to continue after lunch.
Judge Motok. Thank you very much, Mr. Kaufman. We will suspend the hearing now for 90 minutes to resume at 2 p.m. Thank you very much.
All rise, veuillez vous lever. Please be seated. Veuillez vous asseoir.
Bonjour à tous.
Judge Modoc, good afternoon. I'd like to begin with an oral ruling regarding the redactions made to the transcript and direct broadcasting today. The Chamber notes that redactions were made to the transcript and to the direct broadcast of the hearing subsequent to an application by the prosecution and which was opposed by the defense. The application of the requested redactions apparently would be a problem and could lead to hearings being held in closed session. The Chamber wishes to recall an earlier ruling during which the Chamber stressed that it is up to the parties and participants to ensure that their submissions are worded in such a way as to avoid going into closed sessions, thus ensuring the transparency of the proceedings and to avoid the disclosure of confidential information. The Chamber would remind the parties to comply with these instructions. Furthermore, the Chamber is of the view that the information that was asked to be redacted and also from the direct broadcast today were limited to identifying information of witnesses and victims mentioned during the submissions. The defense disclosed information on several occasions that allowed for the identification of victims and witnesses. For example, positions held and nicknames, things that must not be disclosed so as to ensure the protection of witnesses and victims. The redactions had only to do with identifying information and were not as general redactions to the events within the case. This was the appropriate recourse to implement the Chamber's duty to protect the safety and well-being, including psychological well-being, the dignity and privacy of victims and witnesses in accordance with Article 68 of the Rome Statute, without having to hold the hearing in private or closed session. Thus, the Chamber has decided to maintain the redactions that were applied earlier and reminds the defense not to disclose information that may not be necessary and information that could identify witnesses and victims in accordance with Article 8 of the Code of Conduct of Counsel. I thank you very much. And Mr. Kaufman, you may now proceed and continue your submissions on the merits. You have until 3 p.m. Thank you very much.
Thank you, Madam President. As you can see, we have a number of yellow post-its on our table here. These are the document identification numbers of all the matters that I'll be talking about. But since we only have until 3 and until 1 hour tomorrow morning, I can provide the ID number if necessary, but I will move on, and we promise to give the Chamber at the conclusion of the hearing the full ID numbers of everything that I've talked about. And if the prosecution obviously wants something as well, he can.
Afternoon, Madam President. I would just ask my friend if he can read out the tab numbers, because every item per the Chamber's instruction, has a tab number. So even if my friend doesn't read out the entire ERN of the page he's citing, the lines, if he gives us a tab number, at least we can check his homework in real time.
Merci beaucoup.
Thank you very much. Counsel, are you in agreement with this position taken by the prosecution?
Du procureur.
Well, the representative of the OTP. Mr. Kaufman, yes, ma'am. Judge Motik, please proceed.
Come to ask myself another question concerning the nature of a common plan theory which applies equally to its subjective requirements. Has the prosecution shown substantial grounds to believe that Rodrigo Duterte's implementation of its fantasy criminal scheme was of such a nature that the murders detailed in its 49 charged incidents would have ensued as a virtual certainty in the ordinary course of events, and that he foresaw that they would occur as a virtual certainty in the normal course of events? Let us take a moment so that I can assure you that these wonderful words, virtual certainty, actually do exist in the court's case precedent and are not a fiction of my own. If you will, please display the first of two citations from the Abdul Rahman, otherwise known as the Ali Kushaib trial judgment from 2025. First of all, paragraph 795. While the common plan between individuals need not be specifically directed at the commission of a crime, it must nevertheless involve a critical element of criminality, meaning that in the context of the specificities of the case, it was virtually certain that the implementation of the common plan would lead to the commission of crimes. We can have a look at paragraph 706, and it talks about the general knowledge requirements, which I am sure Your Honours are very familiar with. So, with respect to the question whether the common plan entailed the occurrence of murders as a virtual certainty, the answer is an emphatic and resounding no. First of all, let us recall what the prosecution defines as the former president's list of high-value targets, what the media calls the kill list, and what one of Mr. Edward Jeremy's quoted witnesses referred to as the dead list. The number of individuals on this so-called kill list, the very list on which the prosecution relies to show that the knowledge that death would ensue, is 4,817. Those who are actually neutralized dwarfs in comparison and stands at 248. So, assuming that neutralized actually means killed, which it does not, then there is no virtual certainty attributable to Rodrigo Duterte that death would ensue from this kill list. Rather, a 5% chance. Let us have a look at a bar chart for exactly the same figures used by the prosecution as distributed geographically. I now turn to the issue of control, as it did or did not manifest itself in the crime base. In other words, can it safely be argued that substantial grounds exist to believe that Mr. Duterte's supposed diktat filtered its way down from his mouth and via his co-perpetrators to those who were supposedly going about committing these murders? how has the prosecution shown the concept of automatic compliance, or even virtually automatic compliance, so essential to its pyramidal structure? Well, by and large, and judging from Ms. Robin Croft's submissions, it would appear that the concept of automatic compliance is substantiated by reference to subjective comments made by perpetrators who talk about their will being controlled. For example, transcript, page 37, line 7 onwards. I felt like that I didn't have any choice but to follow their orders. It wasn't possible not to obey his commands. Another example, transcript, page 38, line 17. Co-perpetrators controlled the will of the physical perpetrators. End quote. According to the prosecution, members of the Davao Death Squad had to seek clearance from Mr. Duterte to conduct killings in Davao City. For this wild assertion, the prosecution relies once again on the evidence of criminals it has recruited, all of whom are inherently unreliable because of their being self-confessed vicious murderers, testifying in return for virtual immunity from proceedings at the ICC. We shall analyze the testimonies emanating from these individuals in detail later in my submissions. Now, I can see Mr. Nichols scribbling away there, but I shall be referring to what are called statements of limited use. As for the other modes of liability charged, ordering under Article 25(3)(b and Article 25(3)(c), aiding and abetting, as I have said, no smoking gun, no evidence of a direct order, solicitation, or inducement with respect to any one of the 49 incidents. No documentary record exists of a presidential order. So how could these orders have been transmitted for the purposes of Article 25(3)(b)? Well, unless Mr. Nichols envisages mental telepathy, I think that we can discount ordering. The prosecution has failed to elaborate in its oral submissions what it means truly by soliciting. If it means the ambiguous public speeches, then it is difficult to reconcile the frequent exhortations to self-defense with soliciting, unless, of course, you accept that Mr. Duterte super craftily inserted these exonerating comments into his speeches in order to craft himself a defense when the day of reckoning would come. As the prosecution asserts, speaking with a forked tongue, sometimes speaking his mind, sometimes saying what he wants you, your honours, to hear. Furthermore, generalized statements months before specific incidents do not establish causation or instruction. For aiding and abetting, there is no reliable evidence that Mr. Duterte provided practical assistance, encouragement, or moral support that substantially affected the commission of a crime, with knowledge of the perpetrator's intent. And finally, on modes of perpetration, modes of liability, I would beg you not to take heed of Ms. Paulina Masseter's assertion that Rodrigo Duterte failed to prevent or punish the prosecution has not charged command responsibility under Article 28. And the reasons for that are clear. It is the same reason why it cannot prove ordering. There is no ascertainable chain of command descending from Duterte at the top via the co-perpetrators, so-called co-perpetrators, all the way down to the crime base. As I said, it all breaks down at the level of the co-perpetrators. And I would ask you very respectfully not to exercise your discretion to requalify pursuant to Regulation 55 of the regulations of the court. But if you do, and you shouldn't, I respectfully submit, you should order the prosecution to resubmit its document containing the charges and its pre-confirmation brief as amended, and to release Mr. Duterte in the interim. Now, I have finished that section of my submission, and I will now turn to the witnesses themselves, and I will be very careful not to mention anything that I'm not meant to. And I will discuss, first of all, the general reliability. A genuine criminal investigation is meant to be directed at establishing the truth. It is meant to elicit facts in an impartial manner and not to present witnesses with a preconceived idea and to seek confirmation thereof, whether it be by way of leading questions or anything else. By this, I mean that the golden thread linking practically every one of the interviews of the prosecution's so-called insider witnesses, who are, for the most part, ruthless criminals, is the a priori targeting of Rodrigo Duterte. In my submission, no real attempt was made to perform this duty of examining exonerating circumstances, or even to establish the existence of other actors who might be responsible for the high incidence of deaths in the context of the war on drugs. Most prosecutors will collate the evidence and thereafter analyze it and decide whether to prosecute with a view to obtaining a reasonable prospect of conviction, which is indeed the standard supposedly applied since Mr. Karim Khan assumed the role of chief prosecutor. A prosecutor is not meant to choose his target in advance and then find the evidence to support a preconceived desire. Now, I'm not going to engage upon a wholesale forensic analysis of the credibility of each and every witness. I am long enough in the tooth to appreciate that issues of credibility and weight are not normally litigated at confirmation, but are left to trial. This case, however, is unique. And as I have said, the prosecution's star witnesses are self-confessed murderers. And most of their statements were taken by the prosecution's investigators with the assurance of limited use. Namely, that anything self-incriminating would not be used against them in proceedings at the ICC. Although Mr. Nichols will undoubtedly tell you that these agreements of limited use are not to be understood as the grant of immunity from prosecution, for all intents and purposes, they are. And I am prepared to wager that we will not see even one, not one, of these incriminating witnesses in a dock at this court, nor in a dock at any court anywhere in the world, after they have been rehoused and given protection at considerable expense to the state parties funding this court. I do not think that I would be alone either in believing that there is something morally repugnant or even questionable from a public policy standpoint to shield not only one, but a number of murderers from prosecution at the ICC just in an attempt to nail Rodrigo Duterte. Indeed, in many common law jurisdictions, the use of a self-avowed murderer to convict an alleged murderer would normally entail vetting and scrutiny of the highest order. Those words, if I'm not mistaken, come from the Crown Prosecution Service's instruction manual. Public source. In fact, I would suggest that it would normally only be approved, firstly, when it is considered of more value to have a suspected person as a witness than as a possible accused. Secondly, whether obtaining the conviction of an alleged murderer is more important than the release of a self-confessed murderer. And finally, whether it is likely that a conviction could be obtained without the cooperation of the self-confessed murderer, or a number of them. Even after this vetting process, most courts in common law jurisdictions require an evidentiary supplement before relying on the sole testimony of a cooperating criminal witness, or what is otherwise called an accomplice witness. Such an evidentiary supplement, in legal parlance, is called corroboration, and rules exist governing what may be deemed suitable corroboration. I'm pretty sure that these considerations were never considered by the prosecution, for one very simple reason. At least two of the most prominent accomplice witnesses were offered up to the prosecution on a silver platter, and I cannot say by who in open session. Neither the Rome Statute nor its accompanying texts regulate the way statements of limited use are employed. I would like the pretrial chamber to consider the way academics and the prosecution itself has qualified the implementation of limited use statements in the past. And I quote from paragraph 49, which is open source, of a chapter on the Office of the Prosecutor in the 2022 edition of the Max Planck Encyclopedia of International Law, written by no less than Judge Betty Höhler of this court. And I quote, "One of the agreements the OTP may enter into during the investigation is an agreement with a person suspected of committing crimes within the jurisdiction of the court, is to provide a statement of limited use. The idea is that the person provides the Office of the Prosecutor with an oral or written statement for the purpose of pursuing leads or developing additional information or evidence on the condition that the statement will not be used against the interviewed person except as stipulated in the agreement. The purpose of such agreements is to ensure cooperation of so-called insider witnesses whom the OTP does not intend to prosecute, but are expected to provide key information or evidence against other, usually more senior suspects." Judge Höhler was effectively relying on footnote 20 to the prosecution's own filing, number 1118, in the Bemba Article 70 case, which states the same thing. Both sources stress that limited use statements should be used as a rule to pursue leads or to develop information, but not apparently, outright at any rate, to serve as the key and main testimony against a suspect. In my opinion, there is a good reason for this, and it is contained in the wording of Article 54, 3d of the Rome Statute, which is cited as the statutory basis for limited use statements. The prosecutor is entitled to enter into such agreements granting limited use on condition that the agreement would not be inconsistent with the statute. And I stress those words, not inconsistent with the statute. Using the evidence of self-confessed murderers to obtain leads or develop evidence from other sources, I would suggest, is consistent with the statute, as mentioned by Judge Betty Hohler. To give a get-out-of-jail card, however, to a whole bunch of murderers in order to fix liability to another, albeit pre-selected individual, also selected of murder, is, in my opinion, totally and wholly inconsistent with the object and purpose of the Rome Statute, which, according to its preamble, oft cited by the victims and the prosecution, is dedicated to the eradication of impunity. In my opinion, granting immunity to a murder suspect for core international crimes would be seen as undermining the object and purpose of the Rome Statute. Accordingly, I would ask the Chamber to find the statements of those witnesses afforded such limited of use and to be of negligible evidentiary weight. Another issue pertaining to the general credibility of the prosecution's witnesses is the way in which they were recruited. In my opening remarks a couple of days ago, I talked about the general fairness of pursuing charges brought by a prosecutor who was formerly a representative for more than 100 victims of Mr. Duterte's alleged crimes. I also talked about a recorded telephone conversation in which one of the participants bragged about acting as President Marcos Jr.'s silent partner for channeling witnesses to the ICC. Apparently, I raised the presidential spokesperson's hackles considerably, so let me quote a bit more so that I can assure her that my cognitive faculties, which she doubted, are in fact intact. And this is what this covertly recorded individual, who I am forbidden from naming, said. They cooperate through me, since I don't hold a position, redacted. But we are able to do it. So what? What happened here is an ICC investigator will give me a list of witnesses, documents they need to bolster the case against Duterte, then I provide it. I give it to the different agencies so it can be approved. There are witnesses who need a pardon. I get the authority from the president, and they are granted a pardon. Basically, like that, it becomes a priority mission of the government. I don't think I've disclosed here, Madam President, any working methodology of the Office of the Prosecutor. So now I turn to the incidents themselves, the 49 incidents. The prosecution invites you to view these incidents as the manifestation of a much larger pattern. To quote the prosecution's very words, in filing number 330 at paragraph 5, the 49 incidents are a non-exhaustive list of examples of the conduct underlying the charges. Indeed, the prosecution speaks of thousands of victims in toto, data sets, and patterns of violence. Now, the defense does not deny that much drug-related violence did occur. It was occurring before Mr. Duterte assumed the reins of power and continued, as we have shown, by way of a sharp increase after he left office. But these grandiose visions of the prosecution are of no avail if the core criminality and incidents alleged in its document containing the charges are not made out. So the question before you is whether there are substantial grounds to believe, firstly, that each of these specific incidents were unlawful killings, namely, deliberate acts of murder, and secondly, that they were knowingly committed to further the criminal objective of the so-called common plan or the state organizational policy with which it has been conflated, and finally, that they are indeed attributable to Mr. Duterte under a recognized mode of liability. Preempting a possible defense, always a good tactic for a prosecutor, unsure of the strength of his own case, there is a heavy reliance on expert analysis of data sets to argue that reported instances of self-defense were statistically improbable. Let me stress that it is the defense's view that if the contextual case depends on the scale of victims, namely thousands, as alleged by the prosecution, then establishing the evidentiary integrity of each charged incident is imperative. In other words, the defense firmly submits that the pretrial chamber should not commit any one of the 49 incidents to trial unless it concludes that there are substantial grounds to believe that Mr. Duterte's criminal linkage and liability has been established for each one. When these 49 incidents are disaggregated and examined one by one, as the statute requires, we submit, what becomes apparent is not the cumulative strength, rather the recurrence of certain symptoms of inherent weakness in the evidence. These weaknesses fall into 6 broad categories. The first is the over-heavy reliance on the testimony of cooperating witnesses who are inherent criminals with an inherent propensity to be unreliable and whose statements, as I mentioned, are not corroborated by external evidence. The second, hearsay attribution, or in less legal parlance, incriminating statements heard from a source twice or even 3 times removed. The third weakness, which infects the evidence, is the fact that some of the victims are unidentified, making it virtually impossible for the defense to pursue its own lines of inquiry. This weakness affects at least 9 out of the 49 incidents. The fourth weakness, documentary records, such as police and forensic reports, are at variance with and are contradicted by testimony of a single prosecution witness. Fifth, the hoary old chestnut of conflicting statements emanating from two or more witnesses testifying to the same event, some contradicting one another, some contradicting even themselves. And finally, the sixth weakness being the repeated absence of any evidence to link the hitmen to our client, despite the prosecution's best efforts to chivvy such linkage out of them. The defense will now show how these identified weaknesses reduce below the substantial grounds threshold the evidence for these incidents in the three counts as they appear in the document containing the charges. Count 1, the alleged murders during the mayoral period. Count 2, alleged murders of HVTs, the high-value targets, during the presidential period. And count 3, barangay clearance operations also during the presidential period. So I shall start with count 1. As we know, the first cluster of incidents falling under count 1 concerns the so-called and totally fictitious Davao Death Squad period. This concerns incidents 1 through 9 of the document containing the charges. The prosecution's attribution theory here is straightforward, that Rodrigo Duterte, as mayor, authorized killings through intermediaries. But when the evidence for this count is examined, as I've already mentioned, not one witness can say that he heard the mayor give an order to kill. The attribution of criminality to Mr. Duterte arises, for the most part, out of assumption layered on top of hearsay, and follows a repetitive pattern which would, as a rule, entail the same mechanism of attribution. Namely, a hitman witness for the prosecution would state that his handler said that clearance came from, and I quote, above. But what does the word above mean? It means an unnamed superior and nothing more. The mode of liability imputed to Mr. Duterte, namely indirect perpetration, requires the prosecution to establish a stable chain of command through which the common enterprise filtered. If there indeed existed a structured approval process, as the prosecution alleges, one would expect operational consistency, not variability. The incidents contained in count 1 are also marked by internal inconsistencies which cannot be reconciled and which are indicative of the fragility of the prosecution's overall case. Incident number 1, for example, is based on the evidence of two witnesses who contradict each other on fundamental and materially crucial issues. Let me explain in more detail. P26, who presents himself as a participant, claims that Mr. Duterte telephoned a redacted third party to order the operation and was told that it was the mayor on the phone. Was told that the mayor was on the phone. Pure hearsay. The prosecution seeks to reinforce this through P2. Yet P2 was not present at the time. He was inactive, for reasons I can't mention, and relies entirely on what he heard from the redacted third party and another individual at a later date. P2's account is therefore pure, unadulterated hearsay. More significantly, it diverges from P26's version on fundamental points. The year of the incident, 2014 and not 2013. The number of victims, 2 rather than 3. The identity of the perpetrators. The channel through which alleged clearance was conveyed, via driver and bodyguard, to a different DDS member rather than through redacted. And if that is not enough, the method of killing, strangulation rather than stabbing, these aren't minor inconsistencies. They concern the core factual matrix. If the pre-trial chamber is unable to determine even these basic circumstances which establish opportunity, method, that, Your Honours, is conjecture. And we would submit that Article 61(7) of the Rome Statute does not permit charges to be confirmed on the basis of conjecture, on the basis of such a weak evidentiary basis. Now, since the prosecution made such a big deal out of incident 3 on Monday and screened the video of the hit job itself, if you recall, the one in a marketplace which was supposedly viewed with approval by our client, I would like to devote a few words to it. If Your Honours follow the transcript that accompanies this video viewing session, the prosecution fixated on the comments of Mr. Duterte telling the person operating the video not to zoom in
Merci.
Judge Motok, thank you, Mr. Kaufman. We've come to the end of today's hearing, the third day. The hearing shall resume tomorrow at 10 a.m. Thank you, parties and participants. I thank our interpreters, the registry, the technical staff, and all those who have allowed this. Yes, Mr. Nichols?
To interrupt, Your Honors, just at the end of the day, but I wonder if we could go into private session for 1 minute before you leave the bench.
Oui, Monsieur Nichols.
Yes, Mr. Nichols?